Hi everyone, today I'm here with Gabrielle Marchetti, the Principal Lawyer of Jobwatch. Gabrielle works with Jobwatch to make sure Victorians, Queenslanders and Tasmanians are able to access services that can assist them when they encounter legal issues in employment. And their services include a hotline for the public to receive advice and referral, legal services for those who have difficulty accessing it, and community education and advocacy on law reforms. So Gabrielle will be here today to talk a little bit about work rights that everyone should know, but especially those who have chronic issues and chronic conditions. And we'll also be going through some of the questions you guys sent in. And yeah, so if you guys have any other questions, just feel free to type it in the chat and we'll get back to you on that. So without further ado, I'll let Gabrielle jump right into it and tell us a bit about herself, her work, and yeah, all the topics we'll explore today.
Thank you, Sam. Thanks everyone for being here. And Sam is going to very kindly put those slides up on share the screen so that you can all see what I'm going to be talking about. Excellent. So the presentation is very much focused on employment rights for people with any chronic health conditions. As you've heard, my name is Gabrielle Marchetti and I'm from an organisation called Jobwatch. And if any of you haven't ever heard of Jobwatch before, I just really hope that by the end of this chat with you, that you will have that name firmly placed in your minds, and that if you ever have any questions in future about your work rights, you will not hesitate to pick up the phone and give us a call, have a chat to us. We will talk you through all your options in your work situation. So let's go on to that first slide. Today's topics, this is what I'm going to be focusing on. Firstly, I'll tell you a little bit more about Jobwatch and the work that we do and how you can contact us. And then I'm going to be talking about how do you know, is disability discrimination in employment unlawful? I'm sure you already know the answer to that is yes, but what are the different pieces of legislation where it is unlawful? And then I'm going to look at the different stages of employment. So discrimination in the pre-employment stage, discrimination during employment, and discrimination at the end of employment. And so there are different options for you depending on what stage of the employment relationship you're at. And then, of course, very happy to deal with any questions. All right, next slide, and you will see a very lawyerly thing to say, the disclaimer, just that I'm not here to talk about anyone's specific situation and legal advice, but of course I very much welcome you to get in touch with us if you do need legal advice about a scenario that you're in. Okay, off to the next slide. And here is our information about Jobwatch. So you probably all know that there are community legal centres scattered all over Australia. There are roughly 200 of us or so around the country, and about 50 or so are here in Victoria. So you might know your local community legal centre. It might be the place that, so for example, Fitzroy Legal Service, Peninsula Legal Service. There are lots of community legal centres scattered around Victoria that are generalist in nature, so you can go there for free and confidential legal advice about a whole lot of different areas of law if you work, live or study within a certain geographic area. But then there are a whole lot of other community legal centres like Jobwatch that specialise in a particular area of law or that target a specific cohort of clients. So in our case, we specialise in employment law, and we operate across 3 states. So we're across all of Victoria, all of Queensland and all of Tassie. And the main thing that we're known for is our telephone information service. And you've got the phone numbers there, depending on whether you're in Metro Melbourne or outside of Metro Melbourne. You can call us Monday to Friday, 9 till 5:30. Wednesdays, we actually are open until 8:30. So we're open late on Wednesdays. And we will give you free and confidential information and referrals about all your different options. So you, for example, you would say to us, this is the situation I'm in. I haven't started employment yet, but I've been made an offer and I've got some questions about it. Or I've already been working for my employer for a certain number of years. I've got some concerns about how I'm being treated. Or it could be at the end of your relationship. You've maybe already ended your employment, but you've still got some questions about how you were treated. So at any stage of your employment, you can give us a call and we will take you through all the state and federal laws that apply in your situation. I also really urge you to have a look at our website, perhaps before giving us a call, because you will see that we have a number of fact sheets, all listed just in alphabetical order. And we've got a couple that are specific to what I'm going to be talking about today. So we've got medical divulgence, for example. So that's all about, what do you need? What kind of health information do you need to tell prospective employers before you start and during the employment if you develop a condition during employment? So those are good fact sheets to start with, and I recommend that you have a look there. Okay, so this next slide is really that starting question about, is disability discrimination unlawful? And I'm sure you already know, yes, it is. The answer, in short, is yes, it is. But I wanted to set out there for you, without getting too technical, too legalistic, I just want you to see that we actually have lots of different pieces of legislation in Australia. And of course, because we are a federation, we have both state and federal laws. So here in Victoria, most employees, most of you watching this presentation, I would expect, are going to be covered by the Fair Work Act, which is a federal piece of legislation. It applies to all, certainly most employees across Victoria, and it's an Australia-wide piece of legislation. So that's the Fair Work Act. It has provisions about disability discrimination. We also have, across Australia, the Disability Discrimination Act. So that's a Commonwealth piece of legislation. Then states, individual states have got their own equal opportunity legislation. So here in Victoria, of course, we've got the Equal Opportunity Act, and I've listed the Queensland and Tassie ones as well because we operate across those states too. And that point at the bottom of this slide, there are similarities between all these different pieces of legislation, but of course, there are also important differences between each one. So the starting position is always just to know that there's lots of different pieces of legislation that apply, that protect you against disability discrimination. The second step, of course, after knowing this, is that you want to find out a bit more about each of these different pieces of legislation to work out, if you are going to make a complaint under one of them, which one is the best one for you. All right.
Where can people actually access this legislation?
Great question. So really, you can go into Google and just put in Fair Work Act or Equal Opportunity Act 2010 Victoria, and Dr. Google will bring up, will spit out the legislation. You do want to make sure, though, when you are relying on Google searches, please make sure that you're getting the most recent version of the legislation, because all legislation gets updated from time to time, and you don't want to be having a look at something that's old and out of date. Yep. Okay, on to the next slide. So now we're going to focus on disability discrimination that can happen at the pre-employment stage. So this is, at the recruitment stage. So you're still a prospective employee and you've applied for a job to a prospective employer. The important thing to know is that you are still protected, and that's wonderfully reassuring that whilst we may often talk about disability discrimination in employment, do not for a second think that that excludes you. If you are at the pre-employment stage, you are still in fact protected. So that's good. So for example, if you have applied for a job and you feel that the arrangements that have been offered to you, the conditions that have been offered to you are different to the conditions, or less favourable really is what I'm getting at, to the conditions that have been offered to other employees, well then that quite possibly is a case of disability discrimination. If you haven't been offered employment and you think that the reason was because of your condition, your medical condition, well then quite possibly there is some disability discrimination that's going on. As we'll see now in the next slide, please, Sam, there is a difference between when you feel that you've been discriminated against and whether or not that discrimination is unlawful. So they're two different things. Sometimes the law basically acknowledges that you may be treated differently, you may be treated less favourably, but it's not necessarily unlawful. So in the box, you'll see on the left-hand side, it's not unlawful if an employer wants to set inherent requirements or genuine occupational requirements for a role and then doesn't offer you the job because they say that you can't do the inherent requirements of the job. Because of your disability, you can't actually carry out those inherent requirements of the job. The law says in those situations, the discrimination will not be unlawful. So, for example, a bricklayer may be required to lift heavy weights and perform repetitive lifting and bending. That's an inherent requirement of the job. And therefore, if you can't do it because of your medical condition, then it may, I'm not saying always in every case, but it may not be unlawful. So it might be okay for the employer to say, sorry, we can't offer you that job because you can't perform the inherent requirements of the job. So when you're asking yourself, well, can I perform the inherent requirements of the job? You really need to be thinking about what are the essential, what does that term inherent requirements mean? It means what are the essential elements of the job? So it's not every single thing in a position description is going to be an inherent requirement of the job. Okay, you really need to think about what are the essential parts of the job. And if you still think you can perform those essential requirements of the job, despite your medical condition and despite your particular needs, then if you haven't been offered the job, or if you feel that the prospective employer is treating you differently because of something they might have found out about you, then think about a possible discrimination claim. All right, let's go on to the next slide, please. So now we've got a question about what you need to tell prospective employers in this recruitment stage. So in the box on the left-hand side, you can see that there's actually no overarching legal obligation to tell your employer about, all your health information. Absolutely not. There's nothing that tells us in black and white, you must always divulge all your health information either before or during an employment relationship. However, on the right-hand side, you'll see that it's a good idea. You should disclose your chronic illness to a prospective employer or to a current employer. This also goes for current employment relationships where you might suddenly be diagnosed with something. It's a very good idea to tell your employer about it if the medical condition is going to impact on the likelihood of you actually carrying out those inherent requirements of the job. And that also, of course, means your ability to do the job safely. You want to be able to, at all times, carry out the job safely. If there's any issue about you not being able to do the job safely, then it's really important that you do tell your employer. So all employers, as I'm sure you know, have an obligation to keep you healthy and safe in your job, and also they have an obligation in relation to everybody else's health and safety at work. So your ability to carry out your job safely is going to impact not only on your health and safety, but of course the health and safety potentially of your co-workers as well. So it's important that your employers do have this information, and rest assured that there are legal obligations on employers to keep your medical information confidential at all times. Okay, so the next issue is about reasonable adjustments, and you can see over on the left-hand side that I've said in the anti-discrimination legislation, and what I'm referring to here is in Victoria, the Equal Opportunity Act, and federally we have the Disability Discrimination Act. So they're the two that I'm considering, I'm referring to as anti-discrimination legislation. Down at the bottom of the column, you can see in orange, I've said there is no such obligation under the Fair Work Act. And this is important because when you're choosing which piece of legislation to make a complaint under, remember that this particular obligation is not in the Fair Work Act. But under the Equal Opportunity Act and the DDA, the Disability Discrimination Act, employers have to, so this is an obligation on them, they have to make any reasonable adjustments that might be necessary in a particular situation. So that means that at any time during the employment relationship, right from when we're prospective employees, if we think that we can do the inherent requirements of the job, but we need some reasonable adjustments made, we can go to the prospective employer or to the current employer and we can say, look, I've just been diagnosed with this, or I've got this particular health condition. I can do the inherent requirements of the job, provided that you make these reasonable adjustments for me. And if the employer still doesn't make those reasonable adjustments, then of course that's going to be an argument of disability discrimination. But have a look at that middle dot point on the left-hand side. I've said a reasonable adjustment is not going to be, it's going to be unreasonable. In fact, an adjustment that you ask for is likely to be unreasonable if it's going to cause your employer or prospective employer unjustifiable hardship, or if the cost is going to be prohibitive for the employer. So look, no two cases are ever the same. The context is so important, and you're always going to have to work out in your given situation and in the context of your particular employer what is reasonable. Reasonable is one of those words that keeps lawyers very busy because it always comes down to the particular facts of your case. So over on the right-hand side, I've got a Q&A. So what if my employer refuses my request to move to a part-time position in order for me to manage my condition? And the answer to this is, well, definitely you should consider, if you've asked your employer or prospective employer to work part-time, let's say, for example, the position was advertised as a full-time position, you went for the job on the basis that it was going to be a full-time position, and then now you're negotiating, they've offered you the job, and now you want to negotiate with them and say, well, actually, I can only do it on a part-time basis. Or even if you've been doing the full-time position for a number of years, it's the same principles exactly. You now want to ask them to work part-time because of your medical condition. Well, you should definitely think about, is my request to work part-time, can I argue that I'm asking for a reasonable adjustment? Think about your particular job. Can you still do the inherent requirements of the job on a part-time basis? Is you working part-time going to cause unjustifiable hardship for your employer? If you think about all those issues and you still conclude at the end of the day that that you think working part-time is would be a reasonable adjustment, well then feel free to insist that they offer that to you. And if they continue to come back and refuse, well then get in touch with Jobwatch or get in touch with, depending on whether you want to go under the state or federal legislation. Here in Victoria, we've got the Victorian Equal Opportunity and Human Rights Commission that has plenty of information available for you. At a national level, you have the Australian Human Rights Commission, and I've got further details in the next few slides. Okay, next slide, please. So now let's focus on discrimination during the employment relationship. And again, in the box, I've just got the basic point for everyone that I'm sure is no surprise, that it is unlawful for employers to discriminate against employees on the ground of their disability. The important thing, though, to remember is that, of course, we do have different pieces of legislation. So even the definition of disability, what actually constitutes a disability, can vary from legislation to legislation. And the way that the law works in terms of defining what amounts to discrimination varies as well between the different pieces of legislation. So it's always just really important when it gets to that point to just read as much as you can, give us a call, talk to us about the pros and cons. If you call us at Jobwatch, we're never going to actually tell you what to do, but we will talk you through the differences between each of the pieces of legislation so that you're well prepared and you're basically empowered to make that decision about what's best for you. So quite apart from the Equal Opportunity Act and the Disability Discrimination Act, remember that we've also got the Fair Work Act. The Fair Work Act is a Commonwealth piece of legislation, and it doesn't so much talk about discrimination being unlawful. It talks about, it prohibits employers from taking adverse action. So that's the term in the Fair Work Act. At the end of the day, it still amounts to pretty much the same thing. So taking adverse action against employers can include dismissing an employee, injuring a person in their employment, negatively altering an employee's position, discriminating between one employee and other employees, or threatening to do any of the above things. So all of these things would amount to taking adverse action. And again, just let me remind everyone that the Fair Work Act prohibits not only discrimination against current employees, but also discrimination against prospective employees. Okay, next. So let's have a look. Just these are all examples of when you'd be able to argue that you have been discriminated against on the basis of your disability. So you've received less shifts in your work than others just because you think, this is what you're going to argue, you've disclosed your condition to your supervisor. Definitely, if you can show that there is that sequence of events and that there's a relationship in time between you making a disclosure to your supervisor, to the boss, to the HR person, whoever it might be, someone who's got some power to hire and fire within your business, you've made the disclosure, and the next thing that's happened is that you've somehow been punished. In this case, the punishment consists of receiving less shifts, having your shifts cut. And you can draw that connection between those two events. You can say the reason that you've been punished is because you made the disclosure. Definitely you should be thinking about making an argument of disability discrimination. Of course, you know, and I'm sure no one who's listening to this is going to be naive. You need to be prepared for the fact that your employer may well come up with other reasons for why they've cut your shifts. They might say, no, the reason is because you were rude. The reason is because you did a bad job with something. You know, they might come up with all sorts of other reasons. But if you can argue, and depending on the evidence that you've got, if you can show that the reason for the cut was because of your disclosure, then that definitely is worth arguing as a disability discrimination claim. The next example, you've been overlooked for advancements in your career, a promotion, because of your particular medical condition and because of the amount of leave that you have to take. Well, again, I would definitely be arguing that it always depends, remember, on the evidence that you've got about this. But if you can show there's no other good reason for your employer to not give you that particular promotion, or, you know, send you on a wonderful, wonderfully enriching conference, let's say, or any kind of professional development opportunity or something that would be an advancement for your career, or they give you less beneficial work, etc. And your argument is the reason that they're doing that is because I've had to take a certain amount of leave in the last 12 months. and all that leave my employer has known it was all associated with my particular disability, well, then definitely worth arguing disability discrimination. And the last one, the last example here is your employer has placed you on restricted duties after learning that you have, it can be any kind of chronic health condition. So again, your employer has learned about your health condition and they're using that information against you. There's no other good reason based on, I mean, when I say good reason, you know, a valid reason that's based on your performance or your conduct to place you on restricted duties. Well, in the absence of any of that other evidence that the employer might have, and you know, as I said, always be prepared for your employer possibly manufacturing some of this evidence. But if the employer doesn't have that evidence, then you should definitely be thinking about arguing disability discrimination. Okay, on to the next slide. So now, the question here is, what should you do if you think that you have been unreasonably treated because of your illness? So, number one, may not always be practical in your particular situation, but we always do suggest if it's okay to do this, if you feel okay to do this, then the starting position is that you should try to resolve these issues with your employer by raising it with the appropriate person within your business. Now, we all know employers come in all shapes and sizes. Some employers have got large dedicated HR teams. Other employers are very small, and the person who is causing you all this grief is perhaps the actual business owner. So much harder to discuss these things with that person, perhaps, but it depends. You need to just think about that. Is it going to be, do I think it's going to help me to raise it internally first before making an external complaint? If the answer to that question is yes, well, then there you go. You can certainly have a verbal conversation, and we would always suggest that you follow up any verbal conversation with an email where you just, in bullet points, nothing too long, but just confirm what you discussed, what you talked about. So something along the lines of, dear so-and-so, thank you for meeting me today, or thanks for your time on the phone. I confirm that we discussed the following issues, and just list them, and you know, and then whatever you've asked for. You know, I'm really concerned about the way I'm being treated. I'd like you to reconsider, or whatever your request might be at the end of that email. It doesn't have to be too formal, but it's a really important thing to capture the essence of whatever you've talked about verbally in a written email, and then send that email to yourself. If you've sent it from a work email, send it to your private email so that you've got a copy of it for your own records, because that's your paper trail. Often we have clients who come to us and say, I've been dismissed, or I've otherwise been punished. I think I've been discriminated against at work because I asked for a reasonable adjustment, or I told my employer about needing time off, or I told my employer about my particular condition, whatever it might be. But when we then ask our client for what evidence do you have that you had told your employer those things, it's obviously really difficult if the only thing you've done is you've had a verbal conversation. That's why it's really good to just keep a paper trail of these conversations. Okay, if you've tried that and it hasn't worked, or you just don't even think that it's going to be worth having that verbal conversation or written in an email, then just go straight to number 2, which is to make an external complaint to the relevant body. Now, in the box at the bottom of this slide, I've said that you can only lodge one complaint about the same issue. So basically the law tries to avoid situations where we can go forum shopping and lodge multiple complaints in different jurisdictions about the same issue. So if for example, you've been dismissed and you're saying that the reason you were dismissed was discriminatory, was because of your disability, well, you need to choose. Do your homework quickly about which jurisdiction you're going to complain in, and then stick with that particular jurisdiction. You can't just go across all the different bodies and lodge a complaint about that same issue in all of them.
What would happen if you actually do that? What would happen if you lodge multiple complaints, say?
Yeah, good question, Sam. Look, sometimes it does happen, and basically what happens is that then, I mean, a lot of the complaint forms are designed to try and avoid this situation, because they will ask you if you've made a complaint about this issue anywhere else, and if you say yes, I've also complained. So let's say, for example, this is the complaint form to the Fair Work Commission under the Fair Work Act, and then you put on that form that you've also complained under the Equal Opportunity Act of Victoria, and you've also complained to the Australian Human Rights Commission under the federal legislation. And so then the Fair Work Commission, probably someone would call you from the registry and they'd say, hey, you know that you can't actually do that. You need to pick one. And if you're still within the time, because we're going to talk about time limits in a second, then they would give you a chance to choose which ones are you going to withdraw and which one do you want to stick with.
Yeah.
All right, so the next slide is, so here we go with some time frames and lodging your complaints. So if you want to, so for example, here in Victoria, the Equal Opportunity Act gives you 12 months to make a complaint. And that's the 12 months is from when you suffered the discrimination, the disability discrimination, to when you actually lodge your claim at VCAT. So VCAT stands for the Victorian Civil and Administrative Tribunal, and it is the tribunal where you have to get your complaint lodged within the 12 months time frame. Before going to VCAT, it's optional. You can go through the Victorian Equal Opportunity and Human Rights Commission if you want. That's not compulsory. But it's a really good place to start, because the Victorian Equal Opportunity and Human Rights Commission will organise a conference, which is like a sort of conciliation conference. These days, they're conducted over the phone, but they might go back soon to doing them face to face. But you can certainly ask. You can tell the Equal Opportunity and Human Rights Commission people whether you have a preference to having it over the phone or face-to-face. And that's an informal opportunity to try to resolve your complaint. So it's cost-free, and what's the worst that can come of having a conciliation conference? I mean, there's everything to gain from going through that process, and nothing to lose apart from some time. And if you don't resolve the matter at that stage, then as long as you're still within that 12-month time frame, then you can still take your matter to VCAT. But as I say, it's not compulsory. You can go straight to VCAT if you want. Just make sure you're within the 12 months to get to VCAT. Alternatively, if you want to lodge your claim under, so this is still for Victorian employees, but if you want to make your complaint under the Australian Disability Discrimination Act, as opposed to our Victorian one, then you only have 6 months from when the discrimination happened to get your complaint lodged with the Australian Human Rights Commission. So you can see that we've got two very different timeframes depending on whether you've gone for the Victorian or the federal, the Commonwealth piece of anti-discrimination legislation. Now that's different again to making a complaint under the Fair Work Act. So the Fair Work Act, remember everyone, that was also a Commonwealth piece of legislation, but that's the one that talks about adverse action, and it treats these adverse action matters very differently depending on whether the adverse action amounts to a dismissal or something short of a dismissal. So if you're complaining about a dismissal, that you've been dismissed and that's the adverse action, that's the discrimination, then the law only gives you 21 days to lodge your complaint, which is such a short time frame. It's really, really tight. People have to act quickly, which is why it's super important that you, when you're not, if you're in that situation, or if one of your friends is in this situation, it's super important that you just get onto it quickly. Tell them they must call Jobwatch, or read up the relevant information and make a decision quickly, because it could be that they've only got a 21-day time frame and they do not want to miss that boat. However, then we go from, it's like going from the sublime to the ridiculous. You go from 21 days, which is such a short time frame, to 6 years to make a complaint if the adverse action is something other than dismissal. So let's remember those examples that we talked about a few minutes ago. For example, the employer cuts your hours or denies you a promotional opportunity. Those examples are adverse action other than a dismissal, and therefore if you want to complain about those types of behaviours, you've got 6 years from when the discrimination happens. So just again, everyone, really different timeframes, really important that you find out about the particular complaint that you're wanting to make. Now, unfair dismissal is something that you've probably all heard about. It's a type of complaint that you can make under the Fair Work Act if you've been dismissed, and in your gut, you've got to really trust that gut instinct. Do you think that what's happened to you is harsh or unjust or unreasonable? So this is quite apart from the discrimination acts that we've talked about. This is a separate complaint. It's under the Fair Work Act, okay? So you've been dismissed and you think that the reason for the dismissal was harsh or unjust or unreasonable. You think that the dismissal does not comply with the Small Business Fair Dismissal Code, which is something that you can, again, just put into Google that term, Small Business Fair Dismissal Code, and it will come up. You can also go, probably a safer way to find this dismissal code is through the Fair Work Commission's website. They will have the most up-to-date version of the Fair Dismissal Code, and small businesses have less than 15 employees. So if you're in a small business, you just want to check, have they actually complied with this Small Business Fair Dismissal Code? If the answer is yes, well, then you can't go any further with the unfair dismissal. But if your answer is no, then definitely keep considering this as an option. And if you don't think it was a case of a genuine redundancy, so then you're through to, okay, next with the unfair dismissal considerations. So let's have a look at a question and answer here on the right-hand side. So I took extended sick leave to manage my condition and then I was dismissed. What can I do? Well, the first step is to consider making, are you going to make, which one do you prefer? Would you prefer making a disability discrimination claim under one of the Disability Discrimination Acts, so the Equal Opportunity Act in Victoria or the Disability Discrimination Act federally, or do you want to make a claim under the Fair Work Act? So that's your first sort of choice. And if you do want to make a claim under the Fair Work Act, again, you've got a choice, because you've got a choice between arguing that it was adverse action, that's what we talked about before, that was also under the Fair Work Act, or are you going to complain that this is an unfair dismissal? So if you go ahead and you lodge an unfair dismissal claim, then your argument is going to be that this dismissal was harsh or unjust or unreasonable. Now, remember, it doesn't have to be all three of those, only one, in order for it to amount to an unfair dismissal. So you're going to say this dismissal was harsh or unjust or unreasonable because there was no valid reason based on my capacity or my conduct, and the employer did not follow a fair process. And if you can show those things, then you'll get up with an unfair dismissal claim.
Yeah, can an employer make the argument that extended sick leave negatively impacts the business?
Yes, so well done. Absolutely, Sam. See how I've said at the bottom, this last point that I've made is that your argument is going to be that the employer didn't have a valid reason based on your capacity. Yeah. Now, of course, you've got to be ready for the argument, and context is always everything. It depends on how much sick leave. I haven't even mentioned whether it's paid or unpaid in this particular scenario, but that's of course going to make a difference. If you are on your paid sick leave and the employer has gone and sacked you because they think that they don't like the fact that you're taking too much sick leave, well, that's completely against the law. So that will, if you go ahead with an unfair dismissal claim, and you've got the evidence to back that up, and that's what's found by the tribunal, that yes, the employer did sack you because in their mind you were taking too much sick leave, that's against the law. That will definitely be considered to be an unfair dismissal. You'll be safe with that. But of course, if it's no longer paid sick leave and you're asking your employer for unpaid sick leave, well, that's where these things really can differ from one case to the other, depending on the context, depending on how large the employer is, etc., how much notice you've given them, how much they know about your particular situation. And that's also where it becomes really important to choose your jurisdiction carefully, because in that situation, it might be much better for you to make a case of disability discrimination under either the Equal Opportunity Act of Victoria or the Federal Disability Discrimination Act, because under those pieces of legislation, remember, you can say, employer, you've got an obligation under those two pieces of legislation to make reasonable adjustments. And the reasonable adjustment that I was asking you for was for some extended sick leave. I wasn't asking to be on indefinite sick leave. I wasn't telling you that I was never going to be able to return to my job. I was just asking for, let's say, for example, 2 months. I needed 2 months off. And in the context of this particular business and my job, that's a reasonable adjustment that I was asking for. And you failed to do that. You just went ahead and dismissed me because you couldn't be bothered making that reasonable adjustment. And so that type of argument might be a much better one. Okay, on to the next. So a couple more bits of information that are really important if you are considering an unfair dismissal argument. So starting over on the left-hand side, if you do go ahead with this kind of complaint, the Fair Work Commission, who's going to be the tribunal considering your complaint, is going to consider all these factors. So they will go through and they'll say, well, was there a valid reason for this person's dismissal? Was the employee notified of that reason? So were they, and the next one is, were they given an opportunity to respond if the reason related to your capacity, let's say, or your conduct? And then there's always that catch-all that again keeps lawyers busy. Any other relevant matters, any other matters that the Fair Work Commission considers relevant. But so that's really important that you just turn your mind to those factors. Was there actually, what's the employer going to say about whether or not there was a valid reason? It's always good to think things through from the other perspective so that you're ready for your argument. And over on the right-hand side, I've got some eligibility issues set out for you. So unfortunately, not every single employee can go for unfair dismissal. Unfair dismissal has some eligibility criteria. So you need to have been employed for a minimum employment period in order to be protected by unfair dismissal. And this is the first of the sort of limiting criteria. I believe I've put it on the next slide, but don't worry, I'll tell you right now what that minimum employment period is. If you're employed by a small business, so remember that's a business that has less than 15 employees, then you have to have been with that employer for at least 12 months before you're eligible for unfair dismissal. Whereas if you're employed by a business that has 15 or more employees, then you need to have been with them for at least 6 months. So there's the 2 different employment periods. Apart from that, you also, your terms and conditions of employment need to be covered by a modern award. Excuse me for doing this, but if you just go to that last point on this column, you can't be earning more than this high income threshold, which currently is $153,600. It's probably going to go up a little bit on the 1st of July, so it's usually indexed every year, but currently that's the amount. So if you're on less than that as your annual earnings, then it doesn't matter whether you're covered by an award or an enterprise agreement, because your wages dictate that you're covered by unfair dismissal laws. However, if you're on an amount, an annual income that is higher than that 153,600, then you would only be eligible for unfair dismissal if your terms and conditions were covered by an award or an enterprise agreement. Okay, so it's a little bit of a convoluted, complicated way, but I hope I've explained that clearly. Okay, on to the next slide, please. So here's a question, which is, my performance has suffered since I started having chronic health issues. Could this be a ground for dismissal? And my answer is, well, yes, potentially. So unsatisfactory performance can give your employer a valid reason to dismiss you. But remember those considerations that I listed under the unfair dismissal complaint mechanism, that if your employer thinks that your performance is suffering, then they must put that concern to you, and they must give you an opportunity to improve or to address your performance. If you haven't been given an opportunity to improve your performance, the employer hasn't spoken to you about these concerns, and if it's just the first time that they've come to you with any kind of allegation about poor performance, and that's the time when they say, listen, you've just been doing a terrible job, I don't know what's going on, but I can't have this, and therefore you're dismissed. Well, that definitely would sound like a good case of unfair dismissal. But if you have had the employer talking to you about these issues, especially if the employer has been trying to accommodate your particular needs, and they've said to you, what do you think we can do? How can we help you to do your job? What do you need from us? And you've been having that conversation over a period of time, and despite that, the performance hasn't improved, well, then at that point, you may not have a good unfair dismissal argument. Okay, so can you all see how no 2 facts are ever going to be the same? It really does depend on the facts of your particular case, because context is everything. Okay, so if you have been dismissed, whether you want to make an argument of unfair dismissal or the other one that I was referring to under the Fair Work Act before, when I said about adverse action, the employer has taken adverse action against you because of your disability, and the adverse action consists of a dismissal. So in both those situations, these are complaints under the Fair Work Act, and you only have 21 days from the dismissal date to make a complaint. Remember, that's totally different from the time limits under the other pieces of legislation, because under the other pieces of legislation, you've got either 6 months or 6 years, 6 months or 12 months under the Equal Opportunity Act or the Disability Discrimination Act. But under the Fair Work Act, if you've been dismissed and you want to complain about disability discrimination, 21 days. So you've got to act super fast.
Are there any provisions for someone who might not have the capacity to make a claim during that period? Is there, for example, if they're hospitalized, or if there's some other issues?
Yes.
Concessions?
Yep, excellent question, Sam. So the only way that this 21 days can be extended by the Fair Work Commission is if the Fair Work Commission is satisfied that there are exceptional circumstances. So exceptional circumstances is actually the term that's used in the Fair Work Act, and there are lots of decisions of the Fair Work Commission interpreting what does exceptional circumstances mean. And basically, time and time again, the Fair Work Commission has confirmed that exceptional circumstances means it can't just be a run-of-the-mill reason. So unfortunately, the fact that lots of people say, I didn't know, I don't know about the law, I didn't know that there was only a 21-day time limit. Unfortunately, that's so common that it's not exceptional. So that's never going to be enough to get you an extension of time. But in the situation that you've just suggested, Sam, where you might have been hospitalised and that's why you weren't able to get your complaint lodged on time, then quite possibly, yes, depending on what evidence you have about that. And especially if you've somehow made it known to the employer that you're not happy about the decision and that you're intending to take some legal action, then that would also help you to get that extra few days or extra few weeks if needed. All right, next. So we've just ended with the Jobwatch phone numbers and the Jobwatch website, but I am really hoping that you all do get in touch with Jobwatch if you've got queries, questions. You check out our website. And of course, if you've got some questions arising from this presentation, very happy for you to send those questions through to Sam, and Sam will forward them to me.